My Lords, before the break, I was addressing the CMA's position that a penalty can be imposed on an undertaking per se, whether or not it's a natural or legal person, and that a civil claim could also be brought against an undertaking per se, regardless of whether it's a natural or legal person. And I pointed out that even the CMA didn't think that was right until very recently. But what I want to do now is plug their current position into the structure of the Act and show you how it works, or I would say doesn't work, in the context of the structure of the Competition Act, and by reference to the provisions that my own friend Mr. Dimitri relied on yesterday. Oh, I'm sorry, I thought you were
just expecting me to.
I was, yes. So I'll start then, if I may, with section 36, which is Authorities Bundle 1, tab 8. Let's look at the original version, page 57. So you'll recollect that section 36 is the fining provision, and of course the text of it echoes EU law. So on making a decision that an agreement has infringed the Chapter 1 prohibition, the director may require an undertaking, which is a party to the agreement, to pay him a penalty in respect of the infringement, and then like provision under section 36(2) for a breach of the Chapter 2 provision. And I've shown you the EU case law and the UK case law, demonstrating why, notwithstanding the words of this provision, in fact, in law, any such decision, penalty, actually has to be addressed to a legal or natural person. And the reason for that that's focused on in the cases I've shown you is the rights of the defence point, which is of course a very profound principle, which requires to be observed in just the same way in the UK regime as in the EU regime. But there's actually a further legal layer as to why that must be the right answer, and it emerges from section 37, which the CMA also relies on. So section 37 is the enforcement provision. If the specified date in a penalty notice under section 36 is passed and there's been no appeal or it's been determined, excuse me, the director may recover from the undertaking as a civil debt due to him any amount payable under the penalty notice. So as my Lord pointed out yesterday, section 37 envisages a claim for civil debt to enforce a section 36 notice. Now, it's so elementary a submission that I'm really embarrassed to make it to the Court of Appeal, but any claim in civil debt would need to be made against a person. It couldn't be made against an undertaking in the abstract. And the CMA's case, and I'll just give you the reference, it's Skeleton 62.2 for this hearing, is that a civil debt claim could just be made against an undertaking. But if one thinks, even for a moment, the shortest moment, about how the CPR works, of course that's not right. Under CPR 2, a defendant to a claim needs to be a person. That's 2.31 in the list of definitions. The service provisions in Part 6 don't have any provisions for service on an undertaking. Now, of course, there are lots of undertakings that are legal persons or natural persons. I'm a barrister who's a sole trader. I'm an undertaking. So if I, heaven forfend, were ever to be sued in relation to the exercise of my business, then one would sue me as a natural person. And so no question of a multi-member undertaking arises. But the problem, the mischief in what the CMA is saying, is that even where the undertaking isn't itself a person, you can just sue an undertaking. And that's absolutely contrary to the basic building blocks of English law. And so I say section 37 reflects the further reason why section 36 decisions need to be directed to persons, because if one imagines a section 37 civil debt claim being purportedly made against, for example, BMW, then BMW would, if one imagines a section 37 civil debt claim being made against BMW UK, so a legal person, as would have to be the case, in circumstances where the decision had been directed to BMW in the abstract, BMW UK would say, hang on, we don't owe this debt. We aren't identified as a debtor in the decision, so you can't bring a claim against us.
Their paragraph 62.2 uses that point as support for the proposition there's nothing surprising about an undertaking being required to respond to a Section 26 notice. But in the present case, they didn't, did they? They did it as their third limb, the belt and braces part of the notice. They issued the notice against the UK subsidiary and the head, the top of the subsidiary.
Yeah, they went for all three.
They went for all three. What does the point actually, how does it arise in the context of the appeal on the facts?
Yes, so...
I understand why you don't want them to get away with too much. I see that, fair enough. But on the facts of the case?
The reason it matters is a mixture of fact and law. So BMW gave all the documents that it could. In English law, I'm going to show you this next. In English law, there is a defence to a Section 26 liability where you don't have access to documents. So by sending a Section 26 notice to BMW UK, BMW UK did and could give all the documents it had and then could say,
I see.
You can't ask for any more.
So you don't want joint and several liability to attach to UK?
I say actually that the Act says that BMW UK cannot be made responsible for producing.
Its parent company.
Yeah, absolutely. Okay. That's what the Act.
And that's the relevance of this point. It's to UK, but not to the head company. It doesn't really.
Well, the reason why they can't serve a Section 26 notice on AG is because of the any person point.
Okay, all right, I got it. I mean, I'm just trying to fit it into the why it really matters.
You're not alone, my lord, but that's how the tectonic plates fit together.
But I mean, in future, in terms of the precedent value of this, if the EU authorities resonate in the UK, the CMA has to do more or less what it did in the present case. It has to find an appropriate person and or serve on the German company. It either has rights to do so extraterritorially or not. It can't pin liability, you say, on the UK company for the failure of the parent because of the indivisible concept of a undertaking. Because of that indivisible
concept, and that's because of the reasonable excuse defence, which I am going to show you.
Okay.
But that's the reason we're all here.
Is that an issue in this appeal, the reasonable excuse?
Well, it's the reason we're here, because if it weren't a defence, if the CMA could do what the Commission purports to be able to do, which in this case would be direct a Section 26 notice.
If you're right in your point of law, then does it arise at all?
If I'm right on the law, then no, because it's not.
Then you're not responsible for your parent.
Absolutely.
Even though you're part of the same undertaking.
Yeah. And you can see that the CMA accepts that, partly because Mr. Mitri cited the reasonable excuse principle yesterday in her submissions by reference to re-arrows, but also because BMW UK hasn't been fined. So my client parent company has been fined, and that's
but on the analysis, well, they couldn't be fined for a procedural infringement. They could be fined for the substantive offence at the end of the day, because that's when joint and several liability comes back in.
Yeah, I make the point that no substantive offence infringement has been made.
I understand. I'm just trying to put these points into the analytical framework.
Yes. Yes, and there's a difference in the statutory framework, which is that there is a reasonable excuse defence to a Section 26 notice, and of course we know that there's no reasonable excuse defence to a Chapter 1 or Chapter 2 prohibition. So that's a demonstrable difference in the framework. So that's Section 37. And after that, Mr. Mitri went to the current enforcement provisions in relation to Section 26 as evidence that further evidence that Parliament intended a Section 26 request to be capable of being directed to an undertaking. So that's Section 40A. So we need to go to tab 9 for that. It was introduced, as Mr. Kennelly said, in 2013. So authorities tab 9.
I'm just going to take you one step further in the analysis we've just been going through.
Yeah.
If you're right, any person includes undertaking, but applying the concept of undertaking, general principles of fundamental rights, you say you can still have an undertaking, but you've got to carve it up a bit. You've got to find the right person within the undertaking upon whom to serve for rights of defence type of reasons.
There are two potential routes. One is that there's no read across, which, as you know, is
or
our
even if there is a
response
read across, you still have to find the right person within the group.
That's exactly it, my lord. You've anticipated almost the whole of the second section of my submission, so yes, that's where I was.
You can sit down now if you want.
I'll keep trying.
That's really helpful. I mean, I'm struggling to get the framework of the analysis straight.
Yes. It is complex and it's multi-layered. So let me take you back to section 40A. So that is the enforcement provision that now applies to section 26 that imposes the civil penalty. And you'll remember that Mr. Mitriou showed you yesterday. So if we look at it to ground our analysis, authorities 1, tab 9, page 110, and subsection 9, so on page 111, you'll remember Mr. Mitriou showed you this, that sections 112 to 115 of the Enterprise Act 2002 apply in relation to a penalty imposed under subsection 1. So we'll come back to section 40A, but perhaps if you could just hold that open and have a look at tab 11, page 155. So this is section 115, one of those provisions that's incorporated. Recovery of penalties. Where a penalty imposed or any portion has not been paid by the date required, text at the end, the CMA may recover from the person on whom the penalty was imposed, any of the penalty and any interest, and in England and Wales, such penalty and interest may be recovered as a civil debt due to the CMA. Now, that clearly envisages that the person against whom a claim would need to be made under section 115, which must be a legal or natural person because that's how the CPR works, will be the same as the person on whom the penalty was imposed under section 40A. And again, if you were the defendant to a claim under section 115, in circumstances where a penalty had purportedly been imposed under section 40A previously on an undertaking at large, you'd say, no, I haven't been told that I owe this penalty. It hasn't been imposed on me. So I have a defence to the civil debt claim.
Can I just test that proposition?
Yeah.
You're drawing a linkage, you're working back from the CPR.
Yeah.
For the purposes of implementation of your penalty, you might have to go against one or more of the companies within an undertaking, but within the body, would you have to go against? Does it necessarily follow that because you might have to do that under the CPR, that you use that as a guide to interpretation of person in 115?
Well, I say you do because if one looks at the text of the provision. At the bottom of the text, the CMA may recover from the person on whom the penalty was imposed. So I don't demur from the idea that a penalty might be imposed on more than one person, more than one member of an undertaking, in principle, if there's more than one in breach. But what I'm saying couldn't happen is you couldn't just have a penalty on an undertaking that could then be enforced by these means, because it doesn't stack up with the words of the statute.
And 115 covers both substantive penalties and procedural penalties.
So 115 is procedural penalties. Section 37, which we looked at before, in slightly different terms but broadly parallel, is the substantive penalties. And I want to bring that point home a bit further, if I may try to do so, by reference to the text of section 40A, which is Authorities 1, tab 9, page 110. You may still have it open. So, section 40A1, where the CMA considers that a person has, without reasonable excuse, failed to comply with the requirement imposed on the person under section 26, it may impose a penalty of such amount as it considers appropriate. So, at first instance, it was common ground that a person in section 40A had to be a natural or legal person because a penalty could only be imposed on a natural or legal person. And I say that must be right for the reasons I've just taken you through in respect of the other bits of the statute. But then if you accept that, if a person, the penalty must be imposed on a person has without reasonable excuse failed to comply with the requirement imposed on the person under section 26. It's quite plain that the person under section 40A, who's the person on whom the requirement under section 26 has been imposed, is the same as a person at the start of that provision. So if you can only impose a penalty on a person, you can only impose the requirement on a person too.
So it's the difference between the definite and the indefinite article.
Yeah. Yeah. But we say there's no other way of reading those provisions that makes them coherent because of their language, but also because of the need to sue a legal or natural person, because you can't just sue BMW or Volkswagen.
If the verb had been that person, would it have made a difference in your analysis?
Well, that would have made it even stronger. I wouldn't. I suggest, my lord. But
As he told, they use the word person, and this is this is enforcement of a breach of Part 1. It doesn't amend. It doesn't expressly say it's amending Section 59.
no, and of course, I mean, this goes to a point that my Lord Chancellor made yesterday, which is how can there be bits of Part 1 that don't incorporate the read across from Section 59? Well, actually, we know it is common ground that there are bits of Part 1 in which the read across isn't incorporated, and I'll take you to one of them later. That's common ground between us and the CMA. And what I'd say about this is that I'm taking you to it because Mr. Dimitri took you to it, but in terms of its utility in interpreting the original intention of the legislator in 1998, this is a 2013 bit of legislation in the ERRA, and so I'm not saying it's irrelevant, but it's of more limited relevance in that purpose. So I'd like then, if I may, to turn away from these provisions and to go to the other provisions where the term undertaking is used in the Competition Act 1998, which were relied on by Mr. Dimitri yesterday. I can take this much more quickly because the other provisions are just inherently less relevant. They're less closely related to Section 26, so they're going to be of less value to your lordships in determining whether a Section 26 notice can be addressed to an undertaking. And
can you help with maybe just as you go along, at least one thing that one could deduce from the use of the nomination of a status is that Parliament addressed its mind to differences in status. So you see individual, person, undertaking used in a variety of different ways. For example, in relation to an interview, you have to interview a person, or a legal person if you have a representative. If Parliament has deliberately chosen different statuses throughout, and in relation to Section 26 they use the broadest possible, then what does that tell us about intention?
yes, I will
But deal with it as you go through. It seems to me we're divining Parliament's intent, and you ask yourself, what has Parliament done, and how many ways has it done it? Does that suggest that it has been very deliberate in its choice?
It's a very fair point, my lord, and there are a number of illuminating examples which I'll take your lordships to. What I would say about it is that it's not a totally watertight scheme if one thinks about the way that the modernisation regulation works, because we know that undertaking was used in the modernisation regulation and then ported across from Regulation 17 rather than Modreg, but into the Competition Act in circumstances where actually undertaking wasn't strictly what was meant, it was person. So there are some illuminating examples, but I can't suggest that they're a complete guide.
Yeah.
So I'd just like to identify the provisions that Mr. Dimitri relied on. There are 4 of them that were actually not contemporaneous to the Competition Act 1998, and I say that they are less useful in determining the intention of the legislator in 1998. And the clue as to which ones they are is that they're the ones where the section number ends in an A because they were added in later. So Mr. Dimitri relied on section 25A, 26A, 28A and 30A. And so I'm not going to focus on those because they were added into the scheme later. But that leaves 3 provisions which I do need to address. And the first of them is section 22, which is at Authorities 1, tab 8, page 50. So this is immunity. So a person who applies for conduct to be considered under this decision must notify the director and apply to him for a decision, effectively for immunity from the application of the Chapter 2 prohibition. And the section relied on by my learned friend is, but the director, subsection 4, but the director may remove the immunity if A and B and then C, he gives notice in writing to the undertaking on whose application the decision was made that he's removing the immunity. So the point that's made against me is that the concept of immunity and removal of immunity is undertaking wide rather than relating to a specific person, even though it's contemplated that a person would go to the director with an application. And what I say to that is, well, of course it is, because since the concept of undertaking delineates the scope of responsibility for a breach of Chapter 2 prohibition, it would be hopeless either to have immunity or to remove immunity in respect of specific persons within an undertaking. It's a bit like saying that liability for a breach falls on an undertaking. That's just circumscribing the scope of the economic unit that is liable, that is immune or is not. So that's a good example of where I say undertaking has been used deliberately, my lord, and for good reason. And section 34(1)(b) is the next one. That's on page 56. This is said to be particularly important. It relates to directions, which, as my lords know, can be given as part of the director or now the CMA's enforcement powers in respect of breaches of Chapter 1 and Chapter 2. So if a person fails without reasonable excuse to comply with the direction under section 32 or 33, the director may apply to the court for an order either as against the defaulter in section A, or the point that's taken against me is if the direction related to anything to be done in the management or administration of an undertaking, requiring the undertaking or any of its officers to do it. And it said, well, it's contemplated here that a court order could be made as against the undertaking or any of its officers. And what I say about that is two things. The first I say is that exactly the same logic applies as to section 37, for example. If you want the order to be enforceable, you're going to need that order to be made against a natural or legal person. So, for example, if you're contemplating a committal application, if the order is breached, you need the order to be made against someone who can be made the subject of an application. And the second thing I'd say is that I think if you look at the context of the legislation, what's being envisaged here is that you've got a person who's subject to a direction, who's failed to comply with the direction. And so the director, DGFT as it then was being told they can either apply to court for an order against the defaulter or against another person related to the same business. And the use of the term undertaking is really saying, look, if you've had no joy as against the original target, you can go somewhere else in relation to the same business and get an order against someone else, against another director, for example, or a head co or whatever. That's how I say that works. And then the last provision that Mr. Mitru relies on is section 58.
Section
58, it's on page 63. And this is about bindingness of findings of fact. So unless the court directs otherwise, a director's finding, so a finding of the DGFT or CMA now, which is relevant to an issue arising in proceedings under the Competition Act, is binding on the parties in certain circumstances. And Mr. Mitru relies on section 58(2), definition of relevant party, which means B, in relation to the Chapter 2 prohibition, the undertaking whose conduct is alleged to have infringed the prohibition. And I say, well, again, that's just a reflection of the fact that liability, the scope of liability for a Chapter 2 breach, falls on an undertaking. It's really, in a way, a very advanced warning of what the court later found in Sumal against the Daimler subsidiary in Spain. You're going to be bound if you're any part of the undertaking that has been the subject of this decision. So again, totally unsurprising, I say, and perhaps illuminating as to my Lord's point about the use of the term undertaking in the Act. Now, may I just respond properly to the point that you asked me, my Lord, before about why that distinction matters under the UK scheme, and I said because there's a defence of reasonable excuse. I want to show you that defence because it really is the bedrock of why ground 2 works the way that it does. So the original version of the reasonable excuse defence is in Authorities 1 tab 8, page 59. And it had 2 limbs as originally drafted. So you'll see that paragraph 42.1 creates the offence. The person is guilty of an offence if he fails to comply with the requirements under section 26. Then subsection 2, if a person is charged with an offence, it's a defence for him to prove that the document wasn't in his possession or under his control and that it wasn't reasonably practicable to comply. And then 42.3, if a person is charged with an offence in respect of a requirements to provide information, a defence for him to prove that he had a reasonable excuse for failing to comply with the requirement. I'll just show you how that works, how the parallel provision is in the modern law before I make my submission on it.
So this is no longer...
That's no longer extant. That went in 2013, that's the criminal offence.
Yeah.
And so section 40A is the successor provision to that. So 40A, which is in the following tab at page 110, says where the CMA considers that a person has without reasonable excuse. So that's where that comes through into the modern law. And as I said before, in practical terms, that's why the CMA haven't got the documents they want from BMW UK. BMW UK hasn't got access to those documents. It's the same for Volkswagen UK, haven't got access to those documents. And unlike the Commission, we know that Parliament has made a choice to say, if you can't get the documents, it's not an offence to fail to provide them. And there is...
Depending upon who the person is.
Yeah. Depending on who the person is, of course, it's, so, yeah, provided that...
So if you're right on person, then it almost inevitably follows that physically they don't have them and they can't compel a parent. So if the parent doesn't play ball, then the parent is, and if they can't be fined, the parent isn't under any pressure. I mean, that's the brute reality of it, isn't it? That parents are under no pressure to actually voluntarily. I mean, it takes a weapon out of the hands of the CMA. I'm not saying it's a good thing or a bad thing, but that's a practical effect of this. It may, I mean, may just be what it is.
Well, with respect, I don't accept that, my lord, because it's not a question of what puts pressure on the CMA. It's a question of whether Parliament would have intended BMW UK.
Understood. But one of the things we're required to look at is effectiveness. What happens if you're right? Because you're trying to whittle down the word a person, fair enough. If you're right, then this is a consequence. Seems to me it's, never mind the facts of this case, if you can't, the CMA can't go over the subsidiary, there's really no pressure on the parent to comply, it just simply digs its heels in. I mean, that just may be what it is.
That's what the legislation says, my lord. That's what Parliament provided for in 1998. And I'm going to give you a number of examples very similar to the one that you've just put to me, where on the CMA's analysis, a person who's never heard of this notice would be committing a criminal offence by failing to comply with it. So there are hard cases in both directions, but given the presumption against extraterritoriality, we say that it's very clear which way the hard cases go.
I think we've worked that one out from Mr. Keneally's solution.
He'll be delighted. So may I show you then the differences between the UK and the EU regimes while I'm on this point, because it's a closely connected point. So I think it's first helpful to disentangle what the Commission could do to try and get documents. So there are two ways by which it's suggested that the Commission could try and obtain documents from a legal or natural person outside the EEA. The first would be to direct the request itself to a legal or natural person outside the EEA. And that's the point that Mr. Kennelly addressed earlier, and explained that the Commission asks for information but has never imposed a sanction for failure to comply. And it's hardly any surprise that it's never imposed a sanction, given recital 23 of the modernisation regulation, which I've shown you, which says that the document production power is intended to enable documents to be obtained within the community. That's how the scheme works. And the second route would be obtaining documents via a member of the undertaking who's in the EEA. If I may say so, Ms. Dimitri rather elided two concepts in her submissions. There's obtaining documents from an undertaking at large that has some presence in the EEA, which is what the CMA says they can do here. And there's obtaining documents from a member of an undertaking that is itself present in the EEA. And we know that the Commission goes for option B. We know that the Commission writes to an EU subsidiary and says, we want all the documents from the undertaking. And we accept, and Mr. Kennelly took you to the documents, we accept that under the EU regime, the Commission considers that it's got the right to ask the subsidiary for all the documents relating to the whole undertaking, whether or not they're in the individual control, whether or not that subsidiary has actually got access to them. So far as the Commission's concerned, it says it matters not if I, a Belgian subsidiary, go to my Japanese head co and say, please can I have these documents? And the Japanese head co says no. The Commission says, well, I can hold you, the Belgian subsidiary, responsible for failing to comply with that document request. And that's the critical difference. We know the UK scheme works differently because of the reasonable excuse defence that's always been there. So we know that the UK powers don't work in the way that the Commission says that their powers work.
I guess it depends on what's meant by reasonable excuse as well.
Well, I don't.
Which we don't have to.
No, I mean, for the purpose of this case, and I suspect many cases, I think it would be quite clear that not being able to access the documents is the key question. And there's authority on this, and I will give you the reference to it. It is. We will give you the reference to it. It's re-arrows, tab 31, and it's page 104 of the 104G of the report in the judgment of Lord Wilberforce. And there's no issue between us and the CMA about what reasonable excuse means or whether that existed for BMW UK in this case. We didn't have access to documents, and the same for VW UK, I think. So that's what the Commission does. And I've got no submission to make about whether the Commission does in fact does in law, in EU law, have the powers that it purports to have, whether it is actually entitled under EU law to write to an EU subsidiary and say, give me all your documents, give me all the documents of the undertaking, regardless of whether or not you have access to them. There's been, Mr. Dimitri showed you one challenge that was brought to an exercise of that power, Chi May, and that was subsequently withdrawn. So the EU courts have never reached a judgment on this. The Commission might not have the powers that it says that it does. Of course, the Commission for this purpose is only in the position of the CMA. It's no more authoritative than the CMA in this respect. But what we do know, and what matters, is that UK law is taking a different approach. Now, I should address the German legislation as well, that was relied on. Now, before I get into the German legislation, my overarching comment is that it's not very clear how German legislation dating to 2019 could be informative about the intention of the UK Parliament in 1998. So, so it's not going to get anyone terribly far, but in any event, very happy to analyse what the legislation says. Now, Mr. Mitri...
That expression, accessible to the undertaking.
Yes, that's it, my lord. And it comes from the ECN directive, which I know you're as familiar with as I do. Let me just show you the German legislation just to remind the court where it all fits in. So, it's in Authorities Bundle 5, it's right at the end of the bundle. I think there was some uncertainty about whether it's got its own tab. I think it's tab 86.
I have assumed that 86 is the translation of 87.
That sounds about right, my lord. Yes, so I'm on page 1985.
My pronunciation in German is not such that I can verify that.
I'm sure you're not alone there, my lord. So 1985. Does my Lord Justice Green have it? I'm sure we can. So bottom of the page, section 59, requests for information. And the key sentence is the third sentence, and that starts 6 lines from the top of sub 1 on the next page. This obligation covers all of the information and documents accessible to such undertakings or associations of undertakings. And as you said, my lord, that appears to have come from the ECN directive. And what the ECN directive seems to do is require member states, current member states, to adopt a similar document obtaining power to the one that the Commission thinks it has under EU law. So I say that doesn't get you anywhere, because we know that the UK Parliament took a different approach. We know the UK Parliament rejected that approach 20 years earlier and put a reasonable excuse defence into English law. And can I also just show you, just so you've got the full context, the explanatory notes, which are also interesting on this, and that's in tab 88, which is page 1989. So the key paragraph is the bottom one on the page, on paragraph 1, the paragraph starting the accessibility.
Sorry, just give that reference.
Not at all. So it's 1989, and the bottom paragraph on that page. So the accessibility of the information in accordance with sentence 3, which is what I've just shown you, also refers to availability within the undertaking, within the meaning of the economic unit. Information is correspondingly also accessible within the meaning of the provision if a parent or sister company can access the information. The approach that we know the UK Parliament rejected. This follows from the material responsibilities of the undertaking as a whole required under the ECN directive. In contrast to the previous legal formulation, it is not necessary to additionally consider whether the specifically addressed legal entity, such as a domestic subsidiary, has the information available or is able to obtain it based on existing legal connections. So I'd say we don't have the prior legislation. That does rather suggest that in between whenever this earlier legislation was introduced and 2019, when the version you have was introduced, German law operated on the same basis as we say the scheme in section 26 worked.
I'm not really making sense of what it says. Even under the previous legal situation, it was already recognised that claims to information between individual entities within an undertaking could arise from their affiliation under corporate law and associated fiduciary duties or contractual relations. What does that mean?
It's impossible to know. I mean, maybe it means that a bit like BMW AG could obtain in response to the Commission's requests in this case all of the documents because it was the head co. could suck the documents up from all of its subsidiaries, there will be circumstances in which one company is able to get documents from another. It doesn't advance things any further, but I say that the 2019 legislation is neutral to the CMA because it reflects the Commission approach, which we know is different, and the previous legislation appears to be rather unhelpful to the CMA.
And that all flows out of Article 8 of the ECA.
It does, yeah. That's right, my lord. So I'd like now, if I could, to address some of the practical consequences that would follow if the CMA's interpretation were correct. So how Section 26 and the related penalty provisions would actually work if you could send a Section 26 notice to a multi-member undertaking, as the CMA says. Now, Mr. Dimitriou's submissions understandably focused on whether the undertaking, qua undertaking, could be bound. But the necessary implication of that is that if the undertaking can be bound, so can every member of the undertaking by virtue of the principle of joint and several liability. And the CMA don't shy away from that. I'll show you that from their skeleton. But it produces some rather extraordinary results. You asked, my lord, yesterday whether there'd be a gap in the system on the CMA's approach. It's not so much that there'd be a gap in the system on the CMA's approach, but more that it would create a system of such extraordinary scope that Parliament cannot possibly have intended the consequences for which the CMA argues. So let me give you a couple of examples. Let's start with the information production obligation, so Section 26, stricto sensu. So if I use the facts of this case just as an example, the Section 26 notice was addressed to BMW UK and BMW AG. Now, the BMW corporate group has got 200 members, give or take. So let's imagine a hypothetical Japanese subsidiary that's also a member of the same undertaking, BMW Japan. And let's imagine that BMW Japan has responsive documents. Now, on the CMA's case, Parliament intended BMW Japan to be bound by the Section 26 notice, to be obliged to respond to it, even though it's not named in the notice wasn't sent to it, and it may never have been aware of the notice. So, my lord, you asked Mr. Kennelly earlier about the safeguards in this system on the basis that the undertaking would be notified of the Section 26 notice. But in the context of a multi-member undertaking, true global corporate, which is the context that this case is really about, then notice to the undertaking qua undertaking will not achieve notice to every possible subsidiary.
That apply under Article 8 of the ECN?
Well, Article 8 of the ECN applies to the Commission's approach. So
Yeah, no, I understood that the same practical consequences would apply, presumably.
yes, it would. It would, but again, we know Parliament took a different route. And I would say it's just not credible that Parliament could have intended BMW Japan to be bound in those circumstances. If Parliament had intended a person to be legally obliged to respond to a Section 26 notice that it had never been sent, that it had never been seen, that would have been in the statutory language. It would have had to be made clear. And so that's why we say that it produces extraordinary results. And that's just the basic Section 26 obligation. Let me layer on top of that the penalties for non-compliance now. So, as you've seen, at the time Section 26 was enacted, there was a criminal penalty for non-compliance. So that was Section 42. So the CMA's case is not just that BMW Japan was intended by Parliament to be bound by the Section 26 notice, but that it was intended by Parliament to have committed a criminal offence by failing to comply with a Section 26 notice that, according to the CMA, it would never need to have been sent. It would never need to have known about, because notice to the undertaking would be sufficient. And the CMA has to say that's unobjectionable.
Can you help me with this? A little bit of difficulty in looking back to a defunct provision and saying that when the CMA exercised its intention, you can look at something which Parliament has discarded. You've got an existing regime which has got 40A, a less extreme version. shouldn't you look at Parliament's intent? Parliament, when it amended provisions, created an updated version, and it may have looked at it in the round and said, this is now my intent, not my old intent, but this is now my intent.
Now, may I make a couple of points about that? The first is that there's nothing when section 40A was introduced as the replacement for section 42 that says this provision was previously territorial only in nature. It had a criminal penalty. We want it to be extraterritorial. So let's get rid of the criminal penalty because we know Stocker and Perry, we know KBR, we know that's terrible for extraterritoriality. So to make this territorial provision into an extraterritorial provision, we're going to swap section 42 for section 48. Absolutely nothing to suggest that.
The problem is the Parliament's intention is one of those wonderful fictions that we all argue about. And you know, either if there's something there, we say the something helps us. If there's nothing there, we say the nothing helps us.
Yeah. Well, look, I hear what you're saying.
I understand the point. I see your point. I do understand.
But I would say that actually it applies with almost the same force in the context of a civil penalty, because it's also the CMA's case that in the BMW example...
But it's still quasi-criminal.
Yeah,
for convention purposes.
Yeah, and they wouldn't have had notice of it. And I say that's just not credible. Just like to give another example of how the CMA's interpretation of section 26 would match up with the scope of criminal and now civil liability. So the CMA say that Parliament's intention was that the undertaking itself could be held criminally liable. And there's no authority for that proposition. We don't think it's right, but I don't want to focus on that. It's a slightly arid debate because there's no authority either way. What I want to focus on is the implications that the CMA's case would have for the civil and criminal liability of the members of the undertaking. So let's have a look at what the CMA say about this, which is in the core bundle. I promised I'd take you to this. Tab 7, page 74. So, paragraph 73. It may just be more efficient if you remind yourselves of, paragraph 63, if you remind yourselves of that. So the CMA is saying there that all of the members of the undertaking would be jointly and severally liable for a civil penalty under section 48. So that goes to the BMW Japan example I've just given you. Under the predecessor provision, section 42, the CMA doesn't know whether Parliament intended there to be joint and several criminal liability for other members of the undertaking. So let's work out how that works with another hypothetical example. Let's imagine another group company, let's call it BMW Asia, and let's say that it's above BMW Japan in the corporate structure and part of the same undertaking. So again, it's not sent the section 26 notice, doesn't know anything about it. In this case, let's imagine that it doesn't have documents responsive to the request, but that because it's a higher company in the corporate organisation, it could call for the documents from BMW Japan. So the CMA's case is that that company would be subject to the obligation to produce documents under the section 26 notice. It could be fined under section 40A on the basis of joint and several liability. And the CMA doesn't know whether, on its own interpretation, Parliament intended BMW Asia to be capable of being criminally liable for not producing those documents. Now, so that's not very satisfactory. the reality is that the purpose of section 42, as it then was, and section 40A, as it now is, was to enable enforcement of compliance with the section 26 obligation. And so it wouldn't make sense if there was a delta between the scope of the liability under section 26 and the obligation under section 42. There's nothing also to say that the intention was to make the civil penalty narrower, in effect, than the criminal penalty. So we say that on the CMA's case, it seems logical that BMW Asia would be criminally liable. And we say that Parliament clearly can't have intended that result. Now, I think Mr. Mitri might call these interorum arguments, or perhaps it might be said that, of course, the CMA wouldn't exercise its powers unreasonably and would only do so in a sensible way. But actually, all I'm doing is showing you the logical consequences of how the CMA say that Parliament intended the power to work. So it's no answer to these points to say, well, of course we wouldn't exercise the full scope of the power when the very bedrock of the CMA's case is that Parliament intended there to be such a power. So that's what I say about why you can't address Section 26 notice to an undertaking. The next question, the one my Lord anticipates in your question, is the read across of the undertaking concept. And that's our respondent's notice point, of course, because the CAT found that there was read across. I think you've heard from Mr. Mitri, and we agree that there are two main questions in this issue, one of which is more important than the other. The first is the source of the contrary intention exception in the legislative scheme, and the second is what the evidence is of contrary intention. I'm going to say very little about the source of the contrary intention exception. It's common ground that the read across of the term undertaking in section 59 applies absent evidence of a contrary intention. Now, we say that as the CAT found, that was provided for by section 5 of the Interpretation Act. CMA don't agree, but they do accept that the definition is subject to a contrary intention exception. And I'll just give you the reference to where that's clearly established. It's Bennion, and that's in Authorities Bundle 5. You don't need to look it up. Authorities Bundle 5, tab 82, page 1963. And Bennion says, look, it makes no difference whether there's specific legislative language envisaging the possibility of contrary intention.
So just give me that page again.
It's Authorities 5, tab 82, page 1963. So it doesn't matter whether this is brought in by section 5 of the Interpretation Act or not. What I want to do is focus on what the evidence is of contrary intention, because that's what really matters. And I want to do that in the following order. I want to address the point made by the Chancellor yesterday. I want to address the point made by Mr. Mitri, the view of the CAT, and then make my positive submission. So if I may turn first to my Lord the Chancellor's point, the point that you made yesterday was that if there was a contrary intention, that undertaking shouldn't be read across into section 26, that would be made clear on the text of section 59. And my Lord, we say with respect that that isn't the case, because it's common ground between the parties that there's at least one other case in Part 1 of the Competition Act where undertaking isn't to be read across, and it's not mentioned in section 59. I'll just show you what it is. It's Authorities Bundle 1, tab 9. Page 82.
Yeah.
And it's section 28. Section 28(4) on page 83. Any person entering premises by virtue of a warrant under this section may take with him such equipment as appears to him to be necessary. Now that's any person being used where clearly the person can only be an individual officer of the CMA or their predecessors. And it's common ground that that's what section 28(4) means, that there's not any read across.
Do you mind just reading out 2A?
Of course. So, Mr. Mitchell, you asked me to read out sub 2A. A warrant under this section shall authorise a named officer of the CMA and any other of the CMA's officers whom the CMA has authorised in writing to accompany the named officer to enter the premises specified in the warrant, using such force as is reasonable and necessary for the purpose. And what, to get my retaliation in first.
Hang on a moment, I'm not following where that is.
Oh, I'm sorry.
Oh, I've got it, yeah.
So her point is that person means named officer or any of the other in context.
In context.
And we agree that that's the case. And the point that I think Mr. Mitri wants to make is that this is obvious from section 28 that person doesn't include undertaking. So it's not the same as section 26 where it's not obvious. I say if you were BMW Japan or BMW Asia, it would feel quite obvious that that there shouldn't be read across into section 26. But what I'm actually citing this section for is as support for the idea that, if I may say respectfully.
Well, the use of the word person in this section doesn't even correspond with the broad definition in the Interpretation Act. It's clearly only referable to a physical person, a human being. Otherwise it makes absolutely no sense whatsoever. So it doesn't really help you because the use of the word person here might be said to be sloppy drafting given section 59, but it's not intended to be an exception to section 59 because it's pointing in the wrong direction. It's not the person which is the corporate entity or the undertaking or whatever. It's an officer of the CMA. Or I don't know, maybe they go with police as well because it's under warrant, isn't it?
I respectfully entirely agree, my lord, and what I would press upon your lordship is that the other bits of the Act where, for example, section 36, 37, where I've shown that references to undertaking clearly don't just mean undertaking because of the clear EU and UK authority, are pointers that actually the scheme is, as I put it in answer to my Lord Justice Green's question, it's not quite watertight as to when person includes undertaking. So it cuts both ways, perhaps. Now what I'd like to do, having addressed my Lord the Chancellor's point, is to take the gauntlet which was thrown down by Mr. Mitri yesterday as to where we say the read across would apply based on our interpretation. I'm going to give you two examples. Both were in the legislation at the time it was enacted, so these aren't afterthoughts. And one of them I would like to hand up because it's not in the bundle. There's no similar objection to this. It was sent over last night. So
It's not behind tab 8.
it's not behind tab 8. It's one of the few provisions of the Competition Act that didn't make it into tab 8. So, So I'll start with that one, which is section 40, limited immunity in relation to the chapter 2 prohibition.
It's been given two, I think you've been given two.
That's right, my lord. There's a section in the statute and a statutory instrument.
Right, limited immunity.
Limited immunity in relation to the chapter 2 prohibition. So it's about conduct of minor significance, means conduct which falls within a category prescribed for the purpose of this section. And the criteria by reference to which a category is prescribed may in particular include the turnover of the person whose conduct it is. And the explanation of the consequence is at sub 3. A person is immune from the effect of the fining provision if, in case of conduct of minor significance. Now, we absolutely accept that in the context of that section, person includes undertaking, because the scope of liability for a Chapter 2 breach is delineated by reference to the undertaking. And I can show you that the legislator thought that too from the statutory instrument that I've also handed up. So this is a 2000 statutory instrument, but it's just to really make the point good about how it all fits together. On the second page of the document you've got, under conduct of minor significance, the category of conduct prescribed for the purposes of section 41 is conduct by an undertaking. The applicable turnover for the business year is less than X. So that's an example where a person does include undertaking.
And these are the most up-to-date versions.
Well, this is the Act as it was first introduced, my lord.
We seem to have, I'm just looking at the amendments, they seem to go up to 2013.
Oh, sorry, the statute is up to date. The statute is up to date, my lord. Sorry.
Yep.
So that's one example where person includes undertaking, and I'll give you another that has made it into the bundle, and that is again tab 8, page 56. Tab 8, page 56, section 35. So this is interim measures. So what happens during an investigation into Chapter 1 or Chapter 2 before the investigation has concluded. So section 35(2), if the director considers that it is necessary for him to act under this section as a matter of urgency for the purpose of preventing serious irreparable damage to a particular person or category of person, or protecting the public interest, he may give such directions as he considers appropriate. Now, it's quite clear in 2A that person could include an undertaking. And of course, we often see that the harm done in the context of competition investigations includes harm to other undertakings, whether they're competing undertakings, for example, in the context of an exclusionary abuse, or undertakings who are purchasers in the context of an exploitative abuse. So no objection again at all to a person including undertaking in that context. So I hope that's allayed the CMA's concerns as to whether the read across would have any purpose on our case.
Not otherwise than these two examples.
Well, these are examples that I pulled out last night, having heard the submission. There may well be others. Yeah. Now I need.
That's important, isn't it?
Oh, I'm sorry.
Could you read out 3? So
Yes, of course. Yeah. So number 3, subsection 3. Before giving a direction under this section, the director must give written notice to the person or persons to whom he proposes to give the direction, and give that person or each of them an opportunity to make representations. So I would say that just as under, I'm sorry, my lord, it's page 56.
I've been reading it, but I'm just wondering, is it still in force? It must have been amended.
It has been amended. I believe it is still in force. Yes, it is. So it's at tab 9, page 99. I just take it from the original version because we're looking at Parliament's intention in 1998. But if page 99 is a better.
Well, it's just a.
So the point against you is that here's a provision whereby you give notice to an undertaking. And you accept.
In the original section 25, I mean, this section 35, as originally enacted, talks about a reasonable suspicion that a Chapter 1 or Chapter 2 prohibition has been infringed.
Yeah.
And that takes you back to the original section 25, which talks in terms of Chapter 1, with reasonable grounds for suspecting one or other type of infringement. So it all ties in with section 25. As it now stands, it actually says this section applies if the CMA has begun an investigation under section 25 and not completed it.
Yes, that's absolutely right, my lord. And I think that both when the legislation was enacted and now, the idea was the CMA started an investigation. They're worried that something needs to be done more quickly than is possible if they wait for their decision, and so they take interim measures in the meantime. But I think that I anticipate that the point that Mr. Dimitriou may wish to make on section 35(3) is that written notice is to be given to the person or persons, and that person should be given the opportunity to make representations. Now, what I say about that is exactly the same as what I say about the read across in section 26 on the basis of Arbed, Axo Nobel, Sumal, Crest Nicholson. If it's being suggested that binding legal consequences are going to be taken as against a particular business, then the person against whom those directions will be made, the measures will be adopted, needs to be given the opportunity to be told about them and to make representations. Because that's the structure of the Act. May I address now the cat's view in the judgment? This is a respondent's notice point. So the cat appears to have reached a different view on contrary intention from the one I'm urging on your lordships. And the reason for that seems to have been that the cat considered that the different persons within a multi-member undertaking should be obliged to respond insofar as they're in the UK. And there's, with all respect to the learned cat, there's an oddity in this aspect of the judgment because it actually identifies why this conclusion isn't right, and recognises the force of the point. So may I just show you that? It's at core tab 15, page 166. Page 166, footnote 46, talking about criminal liability, and says the offence refers to persons, presumptively including undertakings, so with the read across. In the case of a notice addressed to an undertaking, if one part of the undertaking breaches the law, the undertaking is responsible, and that criminal responsibility affects every other part of the undertaking, because undertaking is a unitary, albeit economic concept. We accept that a court would strain against such an outcome, but that is an indication towards a contrary parliamentary intention in relation to the CMA's construction. So that's the cat recording the point that I've made about criminal liability of BMW Japan and BMW Asia, and saying a court would strain against that outcome. The way this seems to have come about is that by this stage in the judgment, the cat's already decided that there's read across from section 59 to 26. Mr. Dimitriou showed you yesterday that's between paragraphs 38 and 42. So it's actually looking at this question in the context of extraterritoriality, but it's really a question about whether a section 26 notice can be addressed to an undertaking. So that seems to be where the cat fell into error, I think, in footnote 46. So, may I turn then to how... Oh, sorry, Willis, did you have a question? No.
No, it's all right.
May I turn...
I'll hang on to them.
I'm very grateful. I'm conscious of the time. I've got one point that will take 2 or 3 minutes, and then perhaps that might be a convenient moment for that. Yeah. So, may I turn then to how we say the legislation does work? So I've taken you through all of the evidence that we say Parliament can't have intended all of the members of a multi-member undertaking to be responsible to answer a document production request sent to one part of the undertaking. And I've also shown you all the results to which that conclusion would lead in terms of the scope of liabilities for fines and criminal penalties. And so I'd submit that it's clear that Parliament can't have intended a Section 26 notice to be capable of being sent to the whole of a multi-member undertaking at large and to bind all the members of it. And as per our exchange a little while ago, you could look at that in one of two ways in terms of how it works in the Act. Either one could say that these points are indicators of contrary intent, as to whether undertaking should be read across into section 26. And that's the way that the debate below was couched, and I think some of the debate yesterday was couched. Or one might say, Parliament intended the UK legislation to work in the same way as this aspect of the EU legislation, from which it was very directly taken. And so there is a read across. So section 26 does include undertaking, but a section 26 notice and any resulting penalty has still got to be sent to the specific natural or legal persons who are expected to respond to it.
Another way of putting it is it must comply with the Human Rights Act.
Well,
because we're dealing with fundamental rights.
I mean, that is certainly a requirement that's very much emphasised by Sumal and Axo Nobel, yes.
But that wouldn't necessarily undermine the extraterritorial effect. It might simply say that when you read the two together, duty of consistency, there's a certain amount of flexing of the concepts in particular circumstances.
Yes. So extraterritoriality is the last point that I want to address, and that will be why, if I'm wrong about the read across, why bringing undertaking into section 26, and even if a section 26 notice can be addressed to an undertaking at large, the provision isn't extraterritorial. But that will take me a little while, so I wonder whether best to do it after the break.
My lord, sorry, just on that point, to take me a little while, I'm just wondering how we're doing for timing, because I do want proper time to reply.
Of course. So Ms. Dimitri indicated that she needed 30 minutes, but that may have changed.
I think, well, that was on the basis that I was going to take all day yesterday, but I did sit down at 3, and I think I'll need more than 30 minutes.
How long will you need?
I think probably up to 45 minutes. I'll try and do it in 30 minutes, but I certainly will need 30 minutes. Possibly.
How much longer have you got, Miss Abraham?
I can be done in 10 or 15 minutes.
Piece of cake.
Sounds as if we should be just about all right to finish. Right, we'll break for 5 minutes then.
Sorry, I didn't realise your plan had changed.
Oh, no, it's because I said on the basis I'll take the day. That's so I'm just
No, I said no, it's mine. It's just, yeah.
I just got slightly freaked and took a little while. Okay, we're going to get
I meant longer than me.
Okay.
Yeah, sorry.
Exactly. That is really awkward. It's like you're getting to because then you say so much time you actually have math.
Absolutely.
Yeah.
Yeah, no problem.
I'm in here, I'm not listening to you.
No, we're fine, bro. Come on.
Yes,
Well,
you're a meme.
overestimating.
You're already a meme, bro.
Just in case, I just didn't want to have an unfair advantage.
Noted.
Add that to my woes.
Yeah.
He's so happy now.
I'm going to.
So the final point I need to address is what if I'm wrong, so that undertaking does fall to be read across into section 26, and I'm wrong again, so that a section 26 notice can be directed to the whole of a multi-member undertaking at large. In that case, the question arises to whether Parliament intended that to be the means by which section 26 would take extraterritorial effect. Because of course, as we discussed at the beginning of my submissions, ground 2 only arises if the CMA are wrong on ground 1. So on this basis, the CMA would have to be arguing that this is the way, the route by which Parliament achieved extraterritoriality for section 26. And so I say there are 6 reasons why this isn't the way that section 26 was made extraterritorial. And the first is that the CMA's ground 2 involves it in arguing that Parliament conveyed an intention that document requests should be able to be made extraterritorially by means of the definition in section 59 that's read into section 26. Now that's as far as one can imagine from clear words providing for extraterritoriality, and I'd say that it's not a credible basis on which a power that would otherwise be purely territorial in scope could be rendered extraterritorial. It would have been clear from the face of the provision if Parliament had intended section 26 to have extraterritorial effect. And that's in particular because, as Mr. Kennelly has pointed out, it's common ground that sections 27 and 28 are purely territorial in effect. So you're trying to do something different in section 26 on this hypothesis. So you make that clear on the terms, on the face of the Act. The second point is that the point as to parliamentary intention sounds with all the more force because the provision in section 59 that's read into section 26 on this basis wasn't in the bill when it was first introduced. It was introduced during the passage of the bill. And so if the purpose of that addition had been to make a power that would otherwise have been purely territorial into an extraterritorial power, that would have left a trace. It's not credible that that change would have been made, making the power extraterritorial without there being any sign of that in the documents relating to the passage of the CA 98. The third point I'd make is that the suggestion that the read across from section 59 produces extraterritorial effect is all the more unlikely in light of the similarity between this aspect of section 26 and the prior legislation, the Competition Act 1980. Now, in the Competition Act 1980, I'd like to show you section 3.7, which is at Authorities 1, tab 4. Page 28. If I could just ask you to read 3 sub 7.
For the purposes of an investigation.
For the purpose of an investigation, that's it, my lords.
Yeah.
Now, it's common ground that this didn't have extraterritorial. It's not common ground. So it's no longer.
Was section 59 in the 1980 Act?
No.
1980 was about single conduct, anti-competitive conduct by single entities, wasn't it?
Quite.
It was sort of to try and fill a gap which was left by the abolition of the Fair Trading Act 1973.
Yeah.
I realised that's the lacuna.
And of course, before the 1998 Act, there wasn't a complete coda for competition law in the same way that there was as a result of the 1998 Act. It was all a bit more disparate. So the point that I was going to make is that if extraterritoriality was added by the 1998 Act, it's very odd that section 3.7 is so similar to section 26. Now, I now understand that it's suggested that section 3.7 was extraterritorial, and that rather undermines the CMA's reliance on all of the explanatory notes and guidance behind the 1998 Act, which were said to have evinced an intention to make the investigatory powers stronger, including giving them extraterritorial effect. So I say that either way the CMA wants to make its case, it's not credible. Now, fourth point I'd make is that another telling point against the CMA's interpretation under ground 2 is that there is no other context in competition law in which the scope of the responsibilities of the foreign members of an undertaking is determined by whether that undertaking happens to have a member that's present in the UK or is a UK national. That's not a litmus test for any other exercise of power under the Competition Act. And if the intention had been to make the document production powers dependent on this novel yardstick, again, the legislator would have said so, and that isn't part of the legislative scheme. The fifth point is that Mr. Kennelly showed you that the presumption against extraterritoriality applies with particular force where the consequence of extraterritoriality would be to criminalise conduct committed overseas, and he showed you KBR and referred to Soccer against Perry. Let's plug that in to the example of BMW Japan, which holds the documents responsive to a Section 26 notice, and on the CMA's interpretation it's bound by that notice, even though it's not sent it and never knows about it. Now, as I pointed out, the CMA has to contend that Parliament intended that BMW Japan would be criminally liable for its failure to produce responsive documents. There's already a very strong presumption that Parliament doesn't intend to criminalise conduct by foreigners abroad, and that presumption must be yet stronger still, where it's suggested that the foreigner doesn't even need to be told about the obligation to which they are subject before committing the criminal offence. That is not a credible reading of the statute, and it cannot have been Parliament's intention. The clearest possible statutory language would be required to justify that conclusion. It's just unreal for the CMA to suggest that Parliament intended to create a result where foreign persons would commit criminal offences by acts done abroad with no prior notice of their obligations through a read-across provision to be found in the middle of a list of defined terms. And the final point is a related point. Ms. Kennelly also shows you that one of the key factors as to whether legislation can be extraterritorial in effect depends on the safeguards for the operation of the power. And in an intervention, when Ms. Kennelly was making submissions, my Lord Justice Green said, well, there is a safeguard here because the Section 26 notice needs to be notified to the person who's subject to it. But of course, under ground 2, not so. Only needs to be notified to a part of the undertaking. So in KBR, for example, safeguards that were considered suitable in the alternative regime were a need for a letter of request from judicial or enforcement authorities, regulation of the uses to which documentary evidence could be put, and requirement for return. We're so far from that in this statutory scheme. It's no wonder that my learned friend didn't mention safeguards in the context of ground 2, although she addressed them in the context of the appeal overall. Under ground 2, the CMA's position is that it doesn't even need to tell the non-UK national of the act that it's required to take outside the UK. And that is as far removed as imaginable from a statutory system with proper safeguards. Now, as you know, we say that Parliament can't have intended Section 26 to work in that way in any circumstances within the jurisdiction or outside the jurisdiction. But if I'm wrong about that, and you think that a Section 26 notice can be served on an undertaking as a whole, notwithstanding the rights of the defence, notwithstanding the EU case law, notwithstanding the UK case law, notwithstanding the Human Rights Act point, then we say that the lack of safeguards on the exercise of the power is the clearest possible indicator that it wasn't intended to operate extraterritorially. Unless I can help any further, that's what I wanted to say.
No, thank you very much, Ms.
May it please your lordships, before responding to the specific points made by my learned friends, and I'll address first of all the points made by Mr. Kennelly and then Miss Abraham's points. We say it's important to stand back and take stock in terms of the consequences of the respondents' arguments if they're right. Now, by reference to the facts of this case, facts of which are in the public domain, the CMA suspects that the conduct under investigation took place under the auspices of a trade association established in Belgium, and that the attendees of the trade association meetings were the parent companies of these undertakings. These two parent companies have their headquarters in Germany, and so it's likely that any documents relevant to the infringement will be held in Germany. And the consequence of my learned friend's argument is that despite the territorial ambit of Section 2, which plainly envisages an infringement decision and a penalty being levied against undertakings based outside the EU that implement an infringement in the United Kingdom, and despite the clear terms of Section 25, which replicate that extraterritorial scope in respect precisely of the CMA's investigatory powers, despite those things, on my learned friend's argument, the CMA would have no effective means of investigating this suspected cartel. And that is in contradistinction to the position of the Commission, which, as you've seen, has served a request for further information on the whole undertaking, such that if there were documents, unlikely but relevant documents in the UK, those documents would be provided to the European Commission. And we say this is simply not something that Parliament could have intended. It's inconsistent with the terms of the Act and inconsistent with a key purpose of the Act. Now, it's self-evident in our, and before I get to that, think about the position of the CMA if my learned friends are correct. So if it's correct that what the CMA needs to do is address a request for information under Section 26 to a specific legal person and enforce it against a specific legal person, and that request can only relate, they say, to the documents of that specific legal person, at least that's Miss Abraham's argument, the CMA would never know which is the correct legal person at the beginning of the investigation. And what could then happen if it gets it wrong is those documents could be squirreled away and destroyed. And that really, really is something which Parliament could not have intended. Now, we say that it's self-evident and trite that where a statute contains a primary substantive provision and then a means of giving effect to that provision, the territorial scope of the substantive provision is highly material. I took you yesterday to the Clark case, which made precisely that point. Now, of course, there is no absolute rule, and each statute must be construed on its own terms. And so the critical point here for the court is, what does the Competition Act say? And you have the points I've just made about the scope of the substantive provisions being mirrored precisely by Section 25, which is what Mr. Kennelly correctly accepted earlier today. So Section 25, let's make no mistake about it, Section 25 shows us that Parliament explicitly addressed its mind to the territorial scope of the CMA's powers, investigatory powers. Then one asks, well, what are the investigatory powers? Because they're not contained in Section 25 itself. They're contained in the following provisions. And those provisions plainly have to be interpreted in light of Section 25, in the context of Section 25, which sets out their territorial scope. Now, Mr. Kennelly said that extraterritorial effect has to be implied in this case, and for the reasons I've just given, it does not. It's express. There's not complete extraterritorial scope. As Mr. Kennelly showed you, Parliament did not accept the effects doctrine writ large. No. It took a particular position, and it drew carefully the bounds of extraterritorial application of the substantive rules and the investigatory powers. Now, Mr. Kennelly had really 2 points on this, on section 25, which we say section 25 is critical. You understand our submissions on that, and I've made the point a number of times now. His response was twofold. He said, first of all, section 26 is not coterminous. And really, the point he was making there was that it applies to innocent parties who may not be responsible for the infringement that is suspected. But that, with respect, is a red herring, because the fact that it may apply to persons who are not involved in the investigation doesn't say anything about the territorial scope of the provision, which is what the court has to determine. What section 25 does is condition and constrain the exercise of the power under section 26. The power has to be exercised for the purpose of an investigation. And to pick up one point that the Chancellor made, I think, my Lord, you said that in the previous version that was expressly stated. It is in fact expressly stated in this updated, the current version, because section 25 says for the purposes of an investigation, and that's defined in section 26 says for the purposes of an investigation.
Yes.
That's defined expressly in section 59 as an investigation under section 25. So it's exactly. So we have that there as well. Mr. Kennelly's second point, he relied on sections 27 and 28, and he said, well, these are obviously not extraterritorial because the CMA can't be expected to enter premises overseas. And we of course, the CMA accepts that. But first of all, it's not right to say that the powers under 27 and 28 are wholly territorial in nature, and I'm not going to repeat the points I made in opening. We've also made them in our skeleton, but it does, for example, they do provide for information which is controlled at the premises in the UK to be obtained, and so that would include information held abroad. But really the key point here is the fact that some powers could not in fact be used extraterritorially because of their substance, because of the way they're drafted, is not a reason to cut down section 26, because as the court held in KBR, and as my learned friend himself accepts, and indeed prays in aid, all provisions of a statute do not have to be given the same territorial effect. And it is with respect, backward reasoning to say, well, some parts of 27 and 28 cannot be exercised extraterritorially. Therefore, we ignore what section 25 says expressly, and we have to read down section 26. We say that reasoning is incorrect. Now, it was put to Mr. Kennelly by the court that Parliament has conferred this power on the CMA to investigate breaches of Section 2 and Section 18 abroad. But on the respondent's construction of 26, the Section 26, the CMA's powers would be toothless, which is indeed our case. And Mr. Kennelly conceded yesterday that the Act does indeed require the CMA to conduct an effective investigation. So he accepted that, and of course he's right to accept that, because Parliament wouldn't have conferred powers under Section 25 to investigate infringements abroad if it didn't intend those powers, that investigation, to be an effective investigation. But Mr. Kennelly said his submission was that the CMA could indeed conduct an effective investigation because it can do, and I'm quoting his words from yesterday, precisely what the Supreme Court said in KBR could be done. They can seek to get information via the appropriate channels. In other words, under provisions for mutual legal assistance. Now, the problem for the respondents is that in this regard, the statutory context of the Competition Act and the legislative history of the Competition Act is entirely different to that of the Criminal Justice Act in KBR. And let's be clear, KBR is not authority for saying that investigatory powers always have to be read down pursuant to the presumption against extraterritoriality, because Parliament always intends documents or investigations to take place via channels of mutual cooperation under international arrangements. That's not what KBR is saying. It's not laying down a general principle. It was the reason in that case and in that statutory context why Parliament found that the presumption was not rebutted in relation to Section 2(3) of the Criminal Justice Act. And it's very easy in our respectful submission to see why that is, because not only did the Roskill report, which preceded the legislation, envisage in terms that this was how information and documents would be obtained. But as the court explained at paragraph 45, and as my Lord Justice Green put to my learned friend this morning, successive acts of Parliament develop the structures in domestic law which permit the UK to participate in international systems of mutual legal assistance in relation to both criminal proceedings and investigations. And as the court further explained at paragraph 41 of the judgment, those acts of Parliament enabled the UK to participate in a number of international treaties for international cooperation, including the European Convention on Mutual Legal Assistance and the Harare Scheme. And what those treaties do is impose obligations, with some exceptions of course, obligations to give effect to requests for mutual legal assistance. And indeed, that's clear. I'm not going to ask you to turn it up, but that's clear from the judgment of the Divisional Court that my learned friend took you to yesterday. I'll just give you the reference. It's at bundle A3, tab 50, page 1035. And I'll just read you what Lord Justice Gross said. So he said that the object of the international scheme is that as between friendly states with whom there are treaty obligations of international cooperation, requests for mutual legal assistance will be acted on, and as quickly as possible, at least unless there are compelling reasons not to do so. So the international system sets up a system of obligation, and it works on the basis of trust and reciprocity. And in the case of serious and complex fraud in particular, the SFO has a power conferred on it by Parliament to investigate in the UK on behalf of overseas authorities, including using Section 2 of the Criminal Justice Act, and we see that in KBR itself referred to. So the court in KBR understandably found that Parliament's intention was that these were the avenues, because of the complex and comprehensive structure that had been instituted, these were the avenues that should be used for obtaining documents from persons in other jurisdictions, and that if Section 223 were used, that would bypass those mechanisms that Parliament had expressly provided for. And we see also in Gorbachev, I'm not going to turn it up again, but in Gorbachev there were also other mechanisms for obtaining documents abroad. Incidentally, in Gorbachev, it's important to recollect, I did point this out yesterday, that the court did not reach a conclusion as to whether documents overseas, as to whether, if we put it this way, the more muscular argument in that case were right or wrong. It expressly held it over for another case. Now, the scheme, by contrast, under the Competition Act is entirely different. The Competition Act contains no power enabling the CMA to request material from abroad, and my learned friend conceded that there's nothing in the legislative history that indicates that information will be obtained through such international arrangements, nothing at all. On the contrary, what you do see in the legislative history is that a key purpose of this legislation, of the Act, is to provide investigatory powers for the CMA and to strengthen them. These are the powers that Parliament envisages will be used to investigate and prosecute these offences. And the CMA is the only public authority charged with investigating breaches of the Competition Act, and its powers are comprehensively set out in the Act. Further, by contrast with the position under the Criminal Justice Act, the CMA has no power to conduct investigations on behalf of foreign competition authorities. And the importance of that point is it goes to reciprocity, because the SFO has those powers, and so one can quite see how reciprocal arrangements work. But if the CMA can't do anything to assist foreign authorities, why on earth should they provide information back? Now, on this point, finally, my friend took you to the Memorandum of Understanding. That
Sorry,
dates...
just by way of clarification, can you give us at some point the reference to the SFO's equivalent powers, which you say are not in the Competition Act?
Yes, so
compare and contrast.
Section 2 of the competition of the CJA, it's set out at paragraph 42 of KBR, which is tab 59, page 1270. Finally, on this point about mutual legal assistance, the high point of my friend's submissions, I think, was the memorandum of understanding, but he fairly accepted that its relevance, we say it's entirely irrelevant as an aid to statutory construction because it's a CMA memorandum. It dates from 2020 and it's entirely incapable of shedding light on what Parliament intended when it enacted the Competition Act. So it's irrelevant, but even on its own terms, it does not provide for information to be exchanged. It sets out a model agreement which might form the basis for future agreement. That's all it does. Now, my learned friend Mr. Kennelly's next...
I think someone's going to tell us whether or not such an agreement
It was, I'm so sorry, it was. It was signed by the CMA in September 2020.
So it is enforced.
Yes.
And what was that? Was the MOU was signed or the model agreement?
The MOU, so there's not the model agreements. There hasn't been an agreement that's been entered into along the
Pursuant
lines.
to the MOU.
Yes. Now, my learned friend's next point related to enforcement. His argument is the fact that a Section 26 notice cannot necessarily be enforced against a person with no assets in the UK demonstrates that Parliament couldn't have intended Section 26 to have extraterritorial effect. That's his argument. But as my Lord Justice Green observed, nothing in the Act requires the enforcement mechanism to be perfect. Indeed, and this is an important point when one is identifying parliamentary intention, Parliament expressly recognised in the case of the substantive provisions, and this is common ground, which it is common ground are extraterritorial, as you've heard, that precisely the same limitation on enforcement would arise. And so if the CMA penalises an entity in the United States, for example, for breach of Section 2, it will impose a penalty under Section 36 and seek to enforce it by civil proceedings under Section 37, and it may not be possible to enforce it. But that doesn't prevent the substantive provisions having extraterritorial reach. And so that does give a very firm indication that the fact that it may be difficult to enforce against an entity...
You're right, because let's assume for the sake of argument that there doesn't need to be an investigation because they've already got all the information they need. So they've got enough evidence of an infringement under Section 2 by, as you put it, a United States parent company, say. They can then issue an enforcement notice against that company under Section 36. The fact that they can't enforce it is tough, but doesn't mean that's not what the statute means.
Precisely so, my lord. And the fact that Parliament has accepted that enforcement may be incomplete, but nonetheless legislated substantively in an extraterritorial way, shows that my learned friend is wrong to make the argument in respect of 26.
It goes back to a point my lord made, I think, yesterday, possibly earlier today, which is that none of this is perfect.
Precisely so. Precisely so. And we say further that the difficulties with enforcement pressed on the court by Mr. Kennelly shouldn't be overblown because it may in fact be very difficult, usually will be difficult for an undertaking engaging in international business, say a large US corporation, to avoid a position where it has any presence in the United Kingdom, which after all is a very large economy in the world. So if it's bothering to restrict competition, take action to restrict competition in the UK, one might think that the normal case would be that it has some presence in the UK.
It might also be the case that the reputational risks that it would face if it didn't comply would be such that it would comply, even if your client didn't actually have to enforce.
My lord, precisely so, because of course there is a reputational risk for non-compliance, and that's something which operates as a deterrent. So yes, we completely agree with that. Now, Mr. Kennelly took you to Perry and relied on the fact that the existence of criminal penalties in Perry meant that the presumption was not rebutted. Now, In Jimenez, there were similar criminal penalties to those in Perry, but this was no bar to rebutting the presumption because the consequence of simple non-compliance was civil. And can I just show you where in Jimenez that is? Because it does rather show that that criminal penalties are not a trump card, as it were, but it all depends on context. So if we go to tab 54 of the authorities, which is, I think, in your volume 3. And you can take it from page 1158. And it's really the sentence that begins, although Part 8 of Schedule 36 imposes criminal penalties for the destruction or concealment of documents referred to in an information notice, the penalties imposed for non-compliance with the notice itself are only civil. And so there were criminal penalties in the same way that there are now criminal penalties in the current version of the Act for a destruction of documents. So the criminal penalties that existed in Jimenez are analogous to the criminal penalties that currently exist in the Competition Act. Though, of course, Section 42 of the Act originally enacted did make simple non-compliance a criminal offence. But we say, of course, that you have to construe the Act as it now stands in its amended form, because Parliament, when amending the Act, considered the coherence and the effect of the statutory scheme when it amended it. We don't say that the original version can't be looked at. Of course, it is an aid to construction. But in any event, for all the reasons we've given in relation to the express wording of the Act, the scheme, context, history and purpose, the existence of criminal penalties in this case do not mean that Section 26 is subject to territorial limitation. Now, something very brief about safeguards. One is the relevance of this point. And when the court goes back to have a look at KBR, what you'll see is that the relevance of the safeguards point is intimately connected with the mutual legal assistance point, because what the Supreme Court was saying was that Parliament, in successive acts of Parliament, has determined that these avenues and treaties for mutual legal cooperation should be the means of obtaining information, and those instruments contain particular safeguards which, if Section 23, Section 2.3 had extraterritorial effect, would be overridden. So it really does come down to statutory construction. And we say, in this case, of course, there are safeguards in the Act. Now, I've addressed those in writing and orally, so I'm not going to traverse over ground that I've already covered. But we do rely, for example, on the fact that if one is sending a Section 26 notice out of the jurisdiction, the court's leave would be required to serve out. And of course, the court has a discretion. And that's precisely the kind of point that in KBR, the court in KBR recognised was an important feature, the discretion of the court. And if an appeal is brought in relation to a penalty under Section 26, the appeal is suspensive. So these are all safeguards that are contained in this particular statutory scheme. Now, a few words about the...
Just a minute, Section 26 notice sent out of jurisdiction needs leave of court.
Sorry, proceedings to enforce, that I made a mistake, proceedings to enforce, my error. Mr. Kennelly sought to rely yesterday afternoon on the absence of any evidence in this case that the CMA has in fact been sending Section 26 notices outside the jurisdiction. And his point appeared to be that the CMA, because of the lack of evidence, he can therefore take it that the CMA has not been sending these notices, and yet the statute hasn't been frustrated. That, I think, was his submission. Now, the position, in fact, on instructions, as indeed, this is not a new point, it was made clear to the court below, is that the CMA has on many occasions issued 26 notices to persons outside the UK. And as I said at the outset, it views this power as essential. Now, this case is of course the first example of where the use of the power has been challenged, and the tribunal was right to place no weight below. The tribunal was right to place no weight below on the CMA's practice. And that's because an administrative practice can't possibly form a basis for construing the statute. And it's why we haven't adduced evidence of fact. That evidence would have been irrelevant. So
Well, it's
there's,
neither here nor there.
it's neither here nor there.
You might be right or you might be wrong.
No, but as I say, we have...
You might not have done it because you thought you couldn't, whereas in fact you could, or vice versa.
Yes, and the point is that the CMA has frequently done it. And then on the position, it was floated that the German Competition Authority would have power to assist the CMA in this case. Again, we've sought to take instructions. We're not, and sought to communicate with the German Competition Authority. We think that it would not be able to use its powers to assist the CMA. It has powers to conduct its own investigation and under the ECN to assist other EU member states, but not outside the EU. But in any event, it's an irrelevant point, because let's say Mr. Kennelly were right that the German Competition Authority could do that in this case. How about the Ghanaian Competition Authority and the Brazilian Competition Authority and so on and so forth? It means nothing to point to one competition authority that might be able to assist. It really is an irrelevant point. On the practice of the Commission, the documents that Mr. Kennelly took you to make our point, and I think this is now accepted by my learned friends, that the Commission can and does impose requests for information on undertakings. And what it does is it tends to serve the undertaking on a constituent part, serve the notice on a constituent part of the undertaking, say a subsidiary located in the EU, but require that subsidiary to produce documents from the undertaking as a whole, including outside the EU. And again, it was said, oh, well, there's no cases on that, but what we've shown you is evidence of the Commission practice. Indeed, those were the points that Mr. Kennelly himself, he took you to documents showing that practice himself. And you've seen the withdrawn challenges, which indicate that that is so. Now,
A bit difficult to read too much into the withdrawal challenges, isn't it? I mean, they could have been withdrawn for 101 reasons.
It is, my lord, yes, but what they do, we're not seeking to read anything into them, only to say that it's evidence that this is the practice of the Commission, because there were challenges against the Commission's act in seeking information from undertakings outside the jurisdiction. So that was the basis for the challenge. So as the textbook and as the OECD submission and as the documents Mr. Kennelly took you to make clear, they're really of a piece with those authorities. Now, my learned friend, Miss Abrams, said, oh, well, that's all very different, but here Parliament has taken a different tack. So she said, well, in the EU, yes, that's fine, the Commission can do that, and we see under the ECN directive that member states of the EU can serve RFIs on undertakings as an indivisible whole. But Parliament has taken a different approach here, and the basis for saying that was the existence of the reasonable excuse defence. But with respect, that simply doesn't work. It really is a classic bootstraps argument, because if we're right that person means undertaking, and a Section 26 notice is given to an undertaking and applies substantively to the undertaking, then there is no reasonable excuse for a subsidiary or a constituent part of the undertaking to say, well, I can't get this information. It will only become a reasonable excuse if my learned friend is right about Section 59 not applying. So it really is a circular argument. She's got to be right in the first place in order for the argument to have any force. If we're right, it simply doesn't arise. Now,
Would there be human rights type of defences? I mean, in theory, never mind the practice, in theory, could someone say the reason excuse I've got is because it would expose me to a penalty in my domestic jurisdiction, that sort of thing?
Well, my lord, 2 points. One is there's no fetter in the statute on what can constitute a reasonable excuse. And so, say for example, take the Japanese example that my learned friend kept coming back to, and let's say that a subsidiary is given a notice of a large undertaking, is given notice in the UK, and Miss Abraham says, oh, well, that might bind the Japanese subsidiary who may have nothing to do with the infringement and may not know anything about it. Well, obviously, if that were true, so if the subsidiary here thought that there was good reason not to notify the Japanese sister company, then that would be a reasonable excuse. If there were good reason, it would be a reasonable excuse. So it's a safeguard, if you like. Now, the same bootstraps argument could be made in respect of EU law, because although that doesn't provide a reasonable excuse defence, what the provisions do say is that there has to be failure to comply with the request for information has to be intentional or negligent. So my learned friend's argument could just as easily be made under EU law, but we know that EU law provides for the RFI to be imposed on the undertaking as a whole. Now, turning to Miss Abraham's submissions more generally, and again standing back before getting into some of the detail, what's the upshot of her submissions? The upshot of her submissions is that on my learned friend's case, Section 59 has next to no effect. Next to no effect. All she could do was point to 2 examples of where person would include undertaking.
Well, one of which was clearly he never would have done because it was directed, as I put it to her, the other way. It was dealing with officers of the CMA.
That's so. I think that to be fair to her, that was a separate point that she was making. But what she did was, you'll recall, she handed up Section 40 of the Act.
Section 40 and Section 35.
That's right, Section 35. And Section 35 is a terrible example, if I may say so, because that involves, on her case, person being given 2 separate meanings in precisely the same section of the statute.
Oh, yes,
That's hopeless. Now, it's worse than this, because not only does my learned friend's argument involve giving no effect or next to no effect to Section 59, but she even says that where the Act talks expressly about an undertaking, the court is to say, oh no, that's not really an undertaking, that's a corporation or a legal person. So what we have, standing back again, is a situation where Parliament has been very, very careful. Parliament has deemed an undertaking to be a person, has expressly defined what person is in this part of the Act. As my Lord Justice Green has said now a couple of times, has carefully calibrated where undertaking is used and where person is used in the various provisions. And on my learned friend's case, person doesn't mean person in Section 59, apart from on 2 occasions. And undertaking doesn't mean undertaking, it has to mean legal or natural person. And that's really hopeless. It really rides roughshod over Parliament's intention and the express parliamentary words. Now, at the heart of my learned friend's submission is that, as a matter of law, a statement of objections and a decision imposing a penalty cannot be addressed to an undertaking as such, but must be addressed to one of the legal or natural persons of which it comprises. And her submission on the back of that is that, therefore, any person in Section 26 cannot include an undertaking. We say that that's incorrect, and I'm going to give you 3 reasons why we say it's incorrect. The first is that the procedural question of who you have to address a decision to is different to the substantive question of what it is that you are penalising them for. And in fact, the various authorities that my learned friend took you to are on all fours with the CMA's position in this case. So in summary, the Commission must impose a penalty in respect of the entire undertaking. That's what
the penalty is based on a percentage of the turnover of the undertaking.
That's right, and that's what
subsidiary.
That's absolutely right. Now, so the Commission must impose the penalty in respect of the conduct of the entire undertaking, That may then be addressed to one or more constituent elements, and my learned friend's case must be addressed to one or more constituent elements of the undertaking. But to repeat, the penalty is not in respect of the conduct of that constituent element, but in respect of the undertaking itself. And in this case, as you've seen, when you were taken to the notice was indeed sent to particular legal persons within the undertaking, but it imposed a requirement on the undertaking itself. So for the submission of my learned friend to make any sense, it would need to go much further. This isn't a case about who to address a decision to, but what is the scope of the obligation that's imposed? And as you saw in Sumal, a person who was not an addressee of a decision was in fact bound by the decision for the purposes of private damages claims. The second point we make is that the case law which my learned friend was dealing with relates on its face to sanctions to which rights of defence attach. Can we just go back to the Arbed case that she took you to and look at paragraph 19.
It's the one we were handed loose.
That's right, the one that you were handed earlier. So if the court has that, in all proceedings in which sanctions, especially fines or penalty payments, may be imposed, observance of the rights of the defence is a fundamental principle of community law. And it's in the context of sanctions cases that the obligation in EU law to address a decision to a particular legal entity within the undertaking arises. And the short point is that a Section 26 notice or request, or indeed a request by the Commission for documents, is not a sanction but an investigative step. And the Aalborg-Portland case, which I took you to in opening, I'm not going to take you back to it, but it expressly makes that distinction, and I made the distinction as I was going through it. What you see in paragraphs 53 and so on is an express statement of the court saying that a request for information is imposed on the undertaking, and then it says in paragraph 60, but a statement of objections has to be sent to a legal entity within the undertaking. So that express distinction is drawn. And the express distinction is also drawn by Article 8 of the ECN directive. Again, I don't turn it up, but I did highlight the point in opening that not only does it require member states to be able to send requests for information to undertakings, but it says in terms, and in addition, they can send them to natural or legal persons. So it draws the distinction. Those words would be OTOs if in fact the Commission had to send them to a natural or legal person. The third point is that there are important differences in this respect between EU law and the particular statutory provisions at issue in this case. Can I just take you first to the Advocate General in AXO, which was the case that my learned friend took you to, because that makes it clear. Let me just find the reference. It's in my bundle 3. I think it may be a different bundle for your lordships, and Mr. Howe will no doubt tell me. 72, tab 72. Sorry, tab 73. That's right. And if it's the Advocate General's opinion that I want to show you on page 1825. And if you look,
Can you just give me the page reference?
of course, it's 1825, my lord.
Yeah.
And if you could have a look, please, under the heading preliminary remarks, so paragraph 36, the fundamental problem of attributing cartel offences is based on the fact that the addressees of the competition rules and the addressees of decisions by the competition authorities are not necessarily the same. Specifically, whether competition rules are directed at undertakings and apply to them directly, regardless of how they're organised and their legal nature. Decisions by competition authorities penalising breaches of competition rules can be directed only at persons, not least because such decisions must be enforced. And then when you look at the footnote, it explains so that as a matter, what was then Treaty Article 2561
provides that decisions of the Commission which impose a pecuniary obligation are to be enforceable. And then you see, for that reason, going back to paragraph 37, in every case in which a competition authority penalises a cartel offence, the question arises as to the attribution of that conduct to a specific person. Sorry, I've got to read the rest of the footnote. So going back to the footnote, it can be, whereas the German language version of the treaty lacks any clarification, it can be inferred from a number of other language versions that enforceable must refer to the enforceability of decisions which are adopted in relation to natural or legal persons. And then we have some examples of the different language versions. And so that's the particular reason why in EU law it's important to address a decision imposing a penalty to a legal entity. But I repeat, the decision is addressed to the legal entity, but finds liability in respect of the indivisible undertaking and imposes a penalty in respect of the indivisible undertaking. And my learned friend took you in Arbed to, if we can go back to Arbed, please, to the part where the court says, oh, it's all about rights of defence. But it is important in that case to see why that was so. And the important point in Arbed was that the Arbed SA, the parent company, wanted to dispute that it was part of the undertaking. Its position was it wasn't part of the undertaking. And so that's what it hadn't had the opportunity to do, because the SO had not been served on it. It wasn't an addressee. And if you can see this, if you have the case there, you can see this from, if we go to paragraph 14, that refers to Arbed SA, that's the parent company. And then you see, if you then look at the relevant, in paragraph 15, the relevant parts of the judgment below, so 94, as regards second, the question whether the Commission breached the applicant's rights of defence by addressing to it a decision imposing on it a fine calculated on the basis of its turnover without first having formally sent it a statement of objections, or even indicated its intention of imputing to it liability for the infringements committed by its subsidiary, the Court observes that the procedural rights on which the applicant relies are in the present case guaranteed by the first paragraph of the ECSC Treaty, which provides that before imposing a pecuniary sanction, the Commission must give the party concerned the opportunity to submit its comments. And then at 95, as to whether in the present case Arbed was given the opportunity to submit its comments before the decision was adopted, the Court finds that the Commission did not at any point in the administrative proceedings formally advise the applicant of its intention to impute to it liability for the conduct of trade Arbed, called into question the statement of objections and accordingly to impose on it a penalty. And so the point here, impute to it liability, didn't indicate to the parent company it was going to find that it was part of the same undertaking. And what the parent company wanted to do was dispute that it was part of the same undertaking. And we see that at paragraph 17 of the judgment, if you go on, we see that point being made there. And we see it also at 18, 17, 18 and 22. So that was the context of the rights of defence point. Now, there is, and this is repeated, this point comes up again in Sumal, if we could just briefly take that up.
I'm just trying to identify where the ground of appeal was that the appellant was not part of the same undertaking. Because that obviously begs the very issue.
It's the imputation of liability, which is imputation of liability is another way of putting part of the same undertaking. The reason it's imputed is because it's part of the same undertaking.
And is there anything which spells out the nature of the actual challenge, ground of appeal?
Yes, so 17 and 18. So by its first ground of appeal, the appellant claims that the Court of First Instance was wrong to reject its plea for annulment, alleging that after having sent Trade Arbed a statement of objections in which all of the objections were attributed to that undertaking, the Commission then took the contested decision against the appellant without first informing it of its intention or of the reasons which in the Commission's opinion justified that course, and without giving it an opportunity to make its point known, the Commission contends that the judgment should be upheld. It submits that the CFI examine the question whether the failure to inform the appellant formally and expressly of the Commission's intention to impute to it liability, that's really the point, for the conduct of trade arbed. So that's the point.
So it was disputing the very definition of undertaking.
Yes, exactly, disputing the very definition of undertaking. And if we pick up Sumal,
The application.
that's exactly the application of the definition in its case. And Sumal is at tab 74.
Yeah.
And if we go to paragraphs 50, so if we go to 1867, page number 1867. We see there at 53 to 55 this theme being taken up of disputing that you're part of the undertaking, or that the liability should be attributed to the particular appellant. But then what we see at 55 is, however, as regards the situation in which an action for damages relies on a finding by the Commission of an infringement under Article 101, in a decision addressed to the parent company of the defendant subsidiary, the latter cannot challenge the existence of an infringement found by the Commission. And so what that's saying, it really goes to my point about why none of this helps my learned friend, because there's a distinction between, in EU law, who the decision must be addressed to. So it has to be addressed to a constituent element of the undertaking, but it's the entire undertaking that's on the hook. And so, as in this case, as I've said, a notice is given to a company within an undertaking, but again, we say it's the entire undertaking that's on the hook. It's exactly the same point. Critically, EU law draws a distinction between undertakings and natural and legal persons. So that's an important point. Whereas by contradistinction, Parliament does the opposite, because Parliament in section 59 has deemed an undertaking to be a person. So that's a very important point of distinction. Parliament has deemed an undertaking to be a person and as to be treated as an indivisible whole. Now my learned friend then said that she reasoned backwards, if I can put it that way, from the CPR in relation to the Act. So she said, well, it's very clear that in English law, as in EU law, a penalty has to be imposed on a natural or legal person, can't be imposed on the undertaking itself. Now, pausing there, of course, that's completely contrary to the express words of section 36, which uses the word undertaking. But she says, because of this EU law line of authority, the penalty has to be imposed on a constituent part of that undertaking. And she then says that's because enforcement is via a civil action for debt. And even though section 37 of the Act says that that's to be enforcements against the undertaking, again, it says it in terms, she says, well, it can't be because the CPR doesn't provide for that. And we say that that's backwards reasoning because, first of all, she's wrong about the CPR. The CPR does not provide that only natural or legal persons can sue. So that's an incorrect starting point. But secondly, how can the CPR inform the interpretation of primary legislation? This is classic RVL territory. Parliament has deemed an undertaking to be a person. Now, Ms. Abram sought to, we did, and I'm not going to repeat the points in opening because I took you through the Act comprehensively to show you that Parliament does indeed
intend that undertakings can take legal steps and notices can be given to undertakings and so on. I'm not going to repeat those submissions. But it is interesting that when Ms Abrams sought to rebut those submissions, she said, well, I'm going to focus on the original provisions of the Act because they're most... I'm so sorry.
Not the A's.
No, not the A's, but a main plank of her own submission is section 40A. You've heard her say that. So there is, I have to make the forensic point, an inconsistency in her submission. But in any event, when she didn't go back over the A's, what she therefore avoided showing you was the provision in section 30A(4), which says in terms that a criminal prosecution may be brought against an undertaking. That really does wipe aside all her points about the CPR. It's classic RVL territory. Now, almost finally, Ms Abrams referred to practical difficulties. I do stand by my characterisation of them as interiorum arguments, I'm afraid. And she says Parliament couldn't have intended the Japanese subsidiary, etc., to be bound by... and I've made my submissions on those things. The Commission does it perfectly happily. Article 8 of the ECN directive envisages precisely that. This is how competition regimes work, and it simply is not right to say, oh, well, it's all very difficult. And I don't think I've got anything more to add to that. We really dealt with the point in opening. Ms Abrams' final submission, she said, well, if I'm wrong about the meaning of section 26, and if in fact section 59 does govern it, she says, well, it can't be. So on this hypothesis, she's accepting our case that a notice is given to an undertaking. She says, well, the presumption against extraterritoriality cannot bind those parts of the undertaking which are outside the jurisdiction. And really, 2 points about that. The first is that she offered no explanation whatsoever, and there is none in her skeleton argument, as to how she gets that from the provisions of the statute. Simply no means of interpreting the statute to achieve that result. And secondly, it is inconsistent with what Mr Kennelly said yesterday when answering a question put to him by my Lord Justice Green. He said any person, section 26, that his presumption against extraterritoriality attaches to any person, and it must mean any person in the UK. But if we're right that person means an undertaking, undertaking means a person, then, and it's a unitary body, then on Mr Kennelly's argument, the undertaking is in the UK because it's an indivisible whole, and person includes undertaking, the undertaking's in the UK, and there just is simply no scope on the statute for further salami slicing of the notion of an undertaking. Unless the court has anything further for me, those are the CMA's submissions in reply.
Thank you very much indeed, Mr. Secretary. Well, thank you to all of you for your excellent submissions, not just those who've made the oral advocacy, but the juniors and solicitors as well. I know a lot of teamwork goes into this sort of case. Won't surprise you to hear that we're not going to deliver judgment at 4:25 on the turn, so we'll reserve our judgment. We'll let you have it in draft as soon as we can. When you get the draft, it's for the purposes of any typographical or similar errors, not for inviting the court to revisit its decision or for you to make further submissions. And please pay attention to the terms of the embargo at the head of the draft judgment. There have been one or two occasions recently when the embargo has been breached either accidentally or by people who should have known better. I'm not suggesting any of you would do that, but it is of considerable importance that the embargo is complied with. Thank you once again.